Maguire and Majesty Coroner for Blackpool and Fylde.
Yes, Miss Watson, I'm sorry we kept you waiting a few minutes.
My lady, not at all. I intend this morning to move on to the second of the four areas that I foreshadowed in outline yesterday. But before I do so, I wonder if I may raise just two matters. Overnight, I have been able to obtain a blank copy of the care plan, which will at least give the court an indication of what information may have appeared on the missing pages of the care plan. It's not likely to be particularly illuminating or helpful once the court sees it, but I will hand it up nevertheless.
Well, it's useful background information, but I don't think it will impinge on the outcome of the appeal.
Indeed, and I thought it also helpful for the court to have a copy of the index which sets out all of the documentation that was before the coroner at the inquest. Rather than, of course, burden the court with all of that documentation, it will give the court at least an indication of the documents that were available to the coroner and the jury, which included medical records, general practitioner records and hospital records, in addition to records from Blackpool Borough Council.
Yes.
I have paginated those documents so that they follow, I hope, the documents that were handed up yesterday and put at the back of Supplementary Bundle Volume 2.
Yes.
They are hole punched but not stapled.
Thank you.
My lady, the second matter that I would like to touch on before moving to submissions on the facts would be to take the court to the coroner's directions to the jury, which may be of some significance if these appeals were to be allowed and the court were to consider remedies. I ought to indicate at this stage that I am hoping that the submissions that I make today can be concluded in broadly an hour, so as to give the court an opportunity to hear any further submissions in reply.
Yes.
The coroner's directions to the jury then can be found in the second volume of the call bundle, behind tab E2, Roman 7. They begin at page 550. I hope that the coroner provided to the jury written directions, which included at page 554 in paragraph 11 a number of questions in order to assist the jury to produce findings and reach a conclusion on the particular issues in the case. That included a question as to what assistance was provided to Jackie during the 21st of February. Did an ambulance crew attend to Jackie after 7 p.m. on the 21st of February, and if so, what happened? And then a broad open question, what happened on the morning of the 22nd of February?
So which question are they, the paragraph 3 is, which question are they answering?
That is
statutory question.
The statutory question of how the deceased came by her death. And so, although directed that how in the circumstances of this case should be restricted to by what means, that the court will see that in fact the jury were asked to consider some fairly wide and open questions. And on the following page...
So again, forgive me, so this is to help them answer the question rather than setting out a series of questions for them to answer.
My Lord, yes.
Yes, I'm
It is
with you.
intended to give the jury an outline of the structure that they may wish to follow and the matters that they may wish to include when answering that statutory question, how the deceased came by her death. And you'll see in paragraph 11 that they are given that permissive direction in deciding upon the contents of paragraph 3, and in particular the question of how Jackie came by her death. You may wish to consider the following questions. My Lord, my Ladies, you'll see on the following page, page 555, paragraph 16, the coroner directed the jury that they could, in the alternative to a short form conclusion of natural causes, return a narrative conclusion. And it's set out at paragraph 16, if you are not satisfied that Jacqueline Maguire died as a result of natural causes, or if you decide that that conclusion does not accurately record how Jackie died, then you may make a narrative conclusion.
Well, the question is not how Jackie died with respect, it's how she came by her death. And one goes back to Jameson for a very clear explanation of what the difference is.
My Lord, that's quite right. My intention in taking the court to those directions was, in effect, to ensure that you had a clear picture, not only of the coroner's reasoning when determining that Article 2 was not engaged, having heard the evidence and further submissions and considered the case of Parkinson, but were then able to see how that translated into the directions that were given to the jury.
But your submission, presumably, is that for whatever reason, the jury went rather wider than the Jameson approach, even though Article 2 was no longer formally before them.
My Lord, yes, but of course it is important to recognise that they were not permitted to include within any narrative judgmental findings or indeed any possible but not probable causes. Moving on, if I may, then to the facts. It is plain to the court, I hope now, that Jacqueline Maguire was not a detained person. That is to say, a detained person in a comparable position to a prisoner or an involuntary patient detained under the Mental Health Act in a secure psychiatric hospital. She was deprived of her liberty pursuant to a standard authorisation under the Deprivation of Liberty Safeguards provided for in the Mental Capacity Act of 2005. The court has been taken to section 48, subsection 2A of the Coroners and Justice Act, where the position of those deprived of their liberty has been set out. I don't ask the court to turn it up, but you have the reference. It is within the first volume of the Bundle of Authorities at page 63, where the Act was amended to insert subsection 2A, which states a person is not in state detention at any time when he or she is deprived of liberty under section 4A, subsection 3 or subsection 5 of 4B of the Mental Capacity Act 2005. It is not understood that in the submissions of Malone Friends Butler Cole, she contends that a deprivation of liberty pursuant to a standard authorisation should be treated in the same way as state detention. And indeed, the concession made in the court below was maintained, and it has been conceded that the fact that Jackie was living under the deprivation of liberty safeguards does not mean that Article 2 is automatically engaged in this case. I ought to make clear that I do not contend that the amendment of section 48 of the Coroners and Justice Act has any direct bearing on this court's decision, but in my submission the character of the regime in which Jackie was being cared for does, and to that extent I am in agreement with my learned friends Butler Cole that the fact that she was deprived of her liberty under a standard authorisation is not irrelevant in the context of this case. It is not irrelevant because it is to be borne in mind in my respectful submission that as a result of the regime under the Mental Capacity Act, she lived in a community residential placement. She had lived there for over 20 years at the time of her death, and it was in fact confirmed in Mrs Maguire's evidence, should the court wish to see a reference, that she had lived there since September of 1993, and the reference can be found in the supplementary bundle at tab B1, page 145 at A. And although I think it may have been suggested that the residential placement accommodated 6 residents, it was in fact the evidence that there were a maximum of 5 residents accommodated in that placement. And you will find a reference to that in the evidence of Chloe the Saint, again in the first volume of the supplementary bundle, behind tab B4 at page 259 D. Within my submissions on the facts, I'll first like to deal with Mrs Maguire's capacity and presentation insofar as there was evidence before the coroner and the jury in relation to that. There is within the supplementary bundle the deprivation of liberty safeguards paperwork, which contains a capacity assessment, and that relates to Jackie's ability to make decisions about her residence and care. That is found in the supplementary bundle behind tab C2 at page 492. In fact, the best interests assessment begins at page 490.
Bundle, so it's called bundle 2.
Supplementary bundle.
Yes. Yes, apologies.
And the capacity assessment, my lord, carried out by a psychiatrist begins at page 500.
And the date of this?
This is, the date appears at the bottom of the previous page, 499, dated the 4th of April 2016. With the capacity assessment, in fact, preceding that, with a date on page 506 of the 27th of March 2016. The conclusion of the psychiatrist was that Jackie Maguire lacked capacity to make decisions about her residence and care by reason of her moderate learning disability associated.
Where are you reading from now? Which page?
I apologise, my lord. It's a summary by me of the assessment that you find between pages 500 and 503.
Thank you.
What you've just summarised is at 504, having regard to the tick box conclusion at 501.
Indeed. On page 500...
The psychiatrist relied upon the exemption to the exemption of the Mental Health Act, which permits learning disability to be treated as a mental disorder for purposes of incapacity.
My lord, that's right. psychiatrist has provided some detail of the limitations or restrictions that Jackie faced at page 503. He notes that her speech is restricted to few words or very basic small sentences, and then goes on in further bullet points to make comments about her physical condition and mood. You've heard already from learned friends about Cole that evidence was given to the inquest by Jackie's mother, Mrs Maguire, as to her presentation. I need not take the court to her oral evidence unless you wish me to, but you will find in the supplementary bundle, volume 1, behind tab 1, pages 146G to 147D, evidence from Mrs Maguire that Jacqueline was more intelligent than people would give her credit for, that she became frustrated when she was not understood, and that frustration would sometimes be manifested in aggressive behaviour or refusals, in particular refusals to go out. But her evidence was that with time and patience, Jackie would collaborate, and she also gave evidence, perhaps at odds with the conclusions of the psychiatrist, that she could hold a conversation with Jackie.
It's perhaps of note that the psychiatrist doesn't deal with the inferred incapacity to make medical decisions or to cooperate in medical interventions. And as this is an issue-specific determination of incapacity, he determined, perhaps rightly, I make no comment about it, to limit himself to the narrow concept in the statutory authorisation. So this was about care and treatment in the residential home.
Oh, yes.
Full stop.
And in fact, there was no specific capacity assessment put before the coroner or evidence before the jury regarding the decision-specific capacity assessment in respect of medical treatment.
In fact, I'm speaking entirely for myself. I wonder what the purpose of this incapacity determination and the dole's authorisation was. She was wholly immobile and not in the least bit resistant to voluntary care being provided by everybody in the home.
Indeed.
It seems it was just the imposition of an informal policy of having a deprivation of liberty authorisation because there was a locked door.
A locked door and, in her case, 24-hour supervision in order to keep her safe.
With which she cooperated, according to the material I've read.
Yes. With which she cooperated and indeed expressed positive feelings about.
Yes. Yes. But be that as it may, she was subject to the authorisation.
She was.
On the issue-specific question of care and treatment in residential care, she was incapacitated, and we have the separate best interests assessment made by the relevant practitioner, which is attached to that documentation.
Indeed. So far as the regime itself is concerned, she was required to live in the residential placement operated by United Response, and as submitted and observed by the court, remained under close supervision and was not free to leave. But as I've highlighted, page 494 of that documentation sets out Jackie's own views, and she was said to like the home and presented as very settled there. When considering the character of the deprivation of liberty in the circumstances of this case, it is my submission that that is a relevant factor. And relevant because, in my submission, this regime can be distinguished from cases of state detention in which the Article 2 duty automatically applies, as Jackie was not detained or deprived of her liberty in what may be described as a closed institution, such as a prison or a secure psychiatric hospital. And the nature of the control and the restrictions that were imposed upon her were quite different. In my submission, it is apparent from the deprivation of liberty safeguards paperwork and the statement of the best interests assessor that her residential placement was one that should be considered akin to her living in her home in the community. At 494, the best interests assessor expressly states it should be considered her home rather than a placement. Furthermore, if the court, insofar as the court may be assisted by the care plan handed up yesterday, which you have in the second volume now of the supplementary bundle at page 698, it is my submission that, albeit not detailed, the support plan indicates that the aim of the supervision provided by carers and support workers within this placement was to support Jackie and promote her freedom and independence of choice. It was in effect a much more open and a much less restrictive regime than is seen in cases involving prison detention or detention by the police, or indeed detention under the Mental Health Act.
But it was still a restrictive regime.
My lady, it was a restricted regime with which Jackie complied, it would appear, voluntarily, insofar as one can use that term in the case of a patient who lacks capacity, but where she's restricted only so far as to protect her. But if she wishes to access the community, if she wishes to access activities, those restrictions are quite different in character, in my submission, to the restrictions that one would see in cases involving so-called state detention, that is in prison, police custody, or indeed in psychiatric hospitals.
But isn't the feature of the arrangement, no matter how collaborative or socially positive that it may be, that if she needs medical attention, if she needs any assistance with anything outside of her social care, as is detailed in the care plan, she has no initiative or ability to be able to access that. That is in the hands of the care home staff and such medical staff as they communicate with.
My Lord, that is of course quite correct on the facts of this case.
What happens to a member of the learning disability community who has Down syndrome and who's living outside the care home is therefore of no relevance to this particular woman. She gets what is made available to her.
My Lord, not dissimilar in my respectful submission to the position of a learning disabled individual who was not within a residential placement but lived at home with their family. They would remain reliant upon the family network to obtain for them and facilitate for them access to medical care within the community. And in the circumstances of this case, the care and support workers at this residential placement fulfilled the same function as a family member might in the community. They were there to enable Jackie to access the same community medical services as a learning disabled person who was living in the community out with a residential unit.
I have some difficulty with that, Ms. Watson. If we look at page 495 and the first half of that page, really the first substantive paragraph, objective, and it's the last three sentences. She needs the help of staff in all her personal care, and then we have this. All other medication is administered by staff, and Miss Maguire does not have a choice as to whether she takes it. Miss Maguire is not asking to go home, and staff would not allow her to exercise this choice because they feel she would be at risk. And then subjective. Evidence that the person lacks capacity to consent to being kept in hospital care home purposed her. Miss Maguire is unable to consent to the above as, because of a lack of capacity, she is not orientated in time or place. And then we had the citation from Lady Hale. So it's not quite analogous to being in a family environment, is it?
My lady, it cannot be said to be on all fours with living within the family environment.
But there's a real restriction there, that she doesn't have a choice whether she takes medication.
My lady, that may, and I say only may, be the position of those living within the community in a family home. Nevertheless, it is of course accepted that Lady Hale was quite right to note that even a gilded cage remains a cage, and that there are obvious restrictions on what Jackie is able to do. But so far as the access to medical services is concerned, I restrict my submissions to that rather than the administration of medication or indeed the administration of treatment. It is her access to medical services and the way in which those services are accessed that in my submission is analogous to the position of a learning disabled person living within the community. And that is,
can I just see where just break down the submission? The Dole's order is designed to protect somebody, and I think it's accepted, it's common ground between you, that the fact that a Dole's order was in place here doesn't trigger Article 2 because it's an entirely different phenomenon from detention. There's no dispute about that. The submissions you're making at the moment go really to vulnerability, don't they? In that it is entirely possible that Jackie might have been looked after at home if the circumstances allowed it. And if I understand your submission, it's that, broadly speaking, the position would have been the same at home as it is in the care home, save that it would be the family who were doing the looking after and the insisting that medication was taken and so on.
my lord, broadly speaking in relation to the regime as a whole, but specifically in relation to the access to medical services.
Yes.
And it is, in my submission, relevant both to vulnerability in particular, but also the assumption of responsibility.
Yes.
As one of the indicia within the Rabone case.
But as my lord has reminded us, the locked door phenomenon is a little bit of a red herring here, it might be thought, because Jackie was immobile. So the papers show us. So
it's certainly my understanding that she had difficulties with mobility, but my understanding is that she was not completely immobile, and indeed there is evidence that she would be able to move around the residential unit.
I see.
The evidence being that...
well, I was reading from page 503. She is totally immobile due to severe degree of kyphosis.
Yes,
it may be not.
That does not quite fit with
Okay.
the evidence that was heard at the inquest about Jackie moving around the home, coming out of her bedroom and being taken into the community, at which time she needed mobility aids.
I see.
I'm not sure what one makes of the best interest assessor's remarks on 495 in the last paragraph, but it seems that he thinks that the safety element, that is the risk that the Dole's authorisation is meant to protect her from, is exploitation, high risk of falls and road traffic, which suggests that he at least thinks that there's some opportunity for her to be subject to those risks, however that comes about.
Yes. Not entirely consistent evidence within that documentation.
No. Well, there it is.
The care plan itself, before I move away from it, at page 698, within volume 2 of the supplementary bundle, does make some reference, albeit very brief, and the court may feel passing reference to access to medical care. That is in the second row of the table under the heading Summary of Support Package, where the support requirements include not only access to the community, but also medical services. so it would appear that part of the care plan envisaged support with accessing healthcare provision. And the inquest heard some evidence regarding the difficulties that Jackie had with medical interventions, and indeed, my lords, my lady, you've heard submissions from learned friends about Cole regarding the evidence of Mrs Maguire as to a refusal to undergo a blood test in 2013, which was set out in documentation within Supplementary Bundle 1, behind tab A2 at page 79, and indeed on the following page, page 80, the request for a home visit in January 2015 for a well-woman check-up. The court may also be interested to read, albeit I need not take the court to it, Mrs Maguire's evidence within the Supplementary Bundle, Bundle 1, tab B1, pages 159 at H to 160 at C. Evidence that, although some considerable time before Jackie's death, when living at home with Mrs Maguire, medication was given to her to lessen her agitation when attending for blood tests, and it seems that the evidence very much focused on that intervention. But Mrs Maguire was specifically asked in her evidence and confirmed that she was not aware of Jackie being given any medication to relieve agitation or facilitate access to medical treatment while she was living in residential placement in Blackpool. And the reference for that evidence is, again, tab B1, pages 163H to 164A. In fact, Mrs Maguire gave evidence that she was told by those at the residential placement that they were not permitted to give Jackie a sedative to facilitate blood tests. That reference is at page 164C. And that evidence was in fact echoed by one of the support workers, Miss Clayton, when she gave evidence, and the transcript of that evidence is at tab B2, page 180 at A and B. Although not within this court's bundle, the general practitioner records indicate, to answer a question of my Lord and Lord Chief Justice yesterday morning, that there had been no emergency admissions in the past, but that Jackie had undergone various investigations, including ultrasound scans, as far back as 2005, urine tests, and she had allowed examinations which had been performed at home visits. That there's evidence of all of that having been carried out without apparent difficulty within the general practitioner's records. The inquest also heard evidence from a support worker whose evidence is within the supplementary bundle at tab B4, that when Jackie had to go to hospital, she did not need sedation, and that evidence is to be found at page 302 behind tab B4 at E to G. There was indeed further evidence presented to the coroner and to the jury regarding Jackie's engagement with medical care, and one staff member gave evidence that whilst there was a degree of reluctance on the part of Jackie to attend her GP surgery, and they had to request home visits from time to time, she would be compliant with the examinations that were carried out, and would on occasion herself request medical attention, and indeed that this court has heard evidence about that occurring on the 20th of February, 2 days before Jackie's death. When considering the regime within which Jackie was living, it is in my submission also of significance that the staff caring for her and supervising her were not medically qualified. The medical advice and treatment provided to residents within this unit was, as I submitted, analogous to that provided to individuals living in the community. That is to say, it was provided via a community general practitioner and, where necessary in an emergency, by calling an ambulance or by attending the hospital. But it is right to say that although the staff were not medically qualified, contrary to the submissions of my learned friend Ms Butler-Cole, they were not untrained. And indeed, evidence was given by a number of witnesses at the inquest regarding that training. It may be helpful to the court to, by way of example, look at, within the supplementary bundle, the evidence of Sharon Simpson behind tab B11. It begins at page 423, but in fact her evidence regarding staff training is set out at pages 450 and 451. Begins at the very bottom of page 450 at H, where she confirmed first aid training was received, that Ms Simpson, as the manager, the registered manager, and other support workers had NVQ qualifications in health and social care, and that was a qualification to enable the support workers, she said at 451B, to deliver the best possible care and support to patients with the characteristics of those living in the unit, the elderly, those with learning disabilities, and so on. She went on to say at E, there was quite a bit of training, e-learning, which covered safeguarding dementia, mental capacity. There was quite a lot of e-learning to do, and so she confirmed, in fact, that training was provided to staff in respect of the Mental Capacity Act, and specifically the deprivation of liberty safeguards. Evidence was also given to the inquest regarding the systems in place to assess the support workers' understanding of that training, and to the effect that monthly audits were carried out to check records to ensure that that training was finding its way into practice. As to record keeping, I will deal with this very briefly, but it is right to say that there was evidence before the inquest that within the residential unit, daily recording charts were used, medical appointment forms were used, and there was a communications book, all of which were used to aid communication between staff members and to facilitate information sharing, both within the residential unit and with those outside that unit, general practitioners, paramedics and the like. And although it was suggested that there were no records made for the 21st of February 2017, the day prior to Jackie's death, in fact there were records before the coroner in respect of that date. A daily recording chart which set out involvement with Jackie in the morning of the 21st of February, and a number of medical appointment forms setting out the interactions with staff and medical practitioners, her GP practice, NHS 111 and the ambulance service. I don't propose to take the court to all of those references, but I will set them out should the court wish to review those. That evidence was set out in
what issue in the appeal does this fine detail go to?
My Lord, I set it out simply in response to the submissions on the facts that you heard from Ms Butler-Cole, which I had understood were to support the submission that there were inadequate systems in place for obtaining and securing medical attention.
Well, could we have the references? It's
The,
probably not necessary to go to them.
The evidence of Cheryl Clayton, one of the support workers, is to be found in the supplementary bundle, volume 1, behind tab B2, pages 195G to H, at page 197B and G, at page 198B and G, and page 199C. Evidence of another support worker, Ms. Egan, behind tab B3 of the same bundle, page 244 at E to H, and evidence from Chloe Le Saint, another support worker, tab B4 of the same bundle, at pages 260H and 206 to 261A, and further evidence at page 277 at B to F. The final area in respect of the facts that I wish to take the court to will be the evidence in respect of Jackie's condition, specifically in the days prior to her death, insofar as that is relevant to whether there was a real and immediate risk to her life, of which the state had or ought to have had knowledge. It is, of course, accepted that there was clear evidence that the support workers were concerned on the 21st and 22nd of February to ensure that Jackie had access to medical care as a result of her condition. But it is right to note that there was evidence from the support worker Chloe Le Saint that on the 20th of February, Jackie was, quote, fine, and that she had been taken out into the community to a local shop to buy a chocolate bar. That evidence was given, and the reference is at Supplementary Bundle Volume 1, tab B4, page 264G. Coming on to the 21st of February, the evidence of support worker Ms. Egan was that she reported to the 111 call handler that she wouldn't say that Jackie was in the best of health at that point in time, but when she was asked questions such as whether or not she was in severe pain, she told them that she didn't think it was that bad. That reference is to be found at tab B3, pages 215H to 219B. And then much evidence given by Chloe Le Saint, who was caring for Jackie on the 21st of February. She said that she was improved in her condition by the time the paramedics arrived in the evening of the 21st. That reference is to be found in the transcript of her evidence at tab B4, page 254A. And she noted that the paramedics were, quote, happy enough to leave her at home. That is to be found, again, tab B4, page 262E. In terms of overnight, Chloe Le Saint gave evidence that she took observations on an hourly basis, and at page 295A to B gave evidence that Jackie did not exhibit any symptoms. The same witness went on to give evidence that Jackie did not present as in need of getting 111 or 999 immediately. And that evidence was given at page 308B to D.
So whose evidence was that?
That's Chloe Le Saint,
Chloe
the same
Le Saint
support
again,
worker. May find it helpful to turn to that particular part of her evidence, that is page 308 behind tab B4 in Supplementary Bundle Volume 1. she's being asked questions there at A about the seizures or fits that had been witnessed earlier in the day, about which Chloe Lassaint was being informed by other staff members. And she was asked, when you saw Jackie, was there anything about the way she was presenting when you saw her that you felt, I need to get 111 or 999 here now? Her evidence was no, because she was very lucid and she just didn't want to give you her blanket, which sometimes she didn't want you to take her stuff, and the sickness part wasn't a lot. But now I know what kind of colour sickness is, and I would have called 999, but I didn't know at the time, I just thought it was like water. It may be of some assistance to the court to put some of that evidence in the context of the medical evidence that was given to the coroner and the jury. Beginning with the evidence of Dr. Miller, an independent expert in gastroenterology instructed to assist the coroner. His transcript of evidence begins, again in the supplementary bundle, behind tab B10 at page 399. But the relevant part of his evidence at page 408, in relation to Jackie's presenting symptoms, it being Dr. Miller's view that she exhibited no typical symptoms. And you'll see that he says at page 408 of F, well, as far as I can see, during weeks and months and even the day before she was taken to hospital, she wasn't complaining, but I haven't seen all the medical records. She wasn't complaining of indigestion or abdominal pain. So she didn't have those typical symptoms. Even at a time when she must have presumably perforated her ulcer, when she was admitted to hospital, her abdomen was said to be soft, and it was said to be difficult to examine her at one stage because she was writhing and moving around. Typically, if you arrive with a perforated ulcer and you get peritonitis, you lie very still. They tend not to move. They lie still and have a really they have a hard, really sort of borderline, something inaudible, peritonitis, which is very tender to touch, which she doesn't seem to have had. So the symptoms were not typical. And you wouldn't, from reading the notes, considering the outcome, say, oh, well, she's got an ulcer or a perforated ulcer, and so on. There was also evidence given to the inquest by the paramedic, his heirs, and it was her evidence that the observations that she had taken were not such as to give rise to any indication of a real and immediate risk to life. Her evidence was that she was clinically, medically stable. That reference can be found behind tab B5 at page 331D. Paramedic Ayres was very clear in her evidence that she would not have sedated Jackie, not only because she said in her evidence it was not within her remit, but also because she said it would be, in effect, too great a risk given her presenting condition. It may be helpful for the court to go to that evidence behind tab B5 at page 331. She begins her answer at the top of that page at A. She said it would have been a case at that point to say, yes, I can't do that, that is sedation. It's not within my remit at all. And with regards to Jackie's state at that time, it would not have been something that they would have thought about doing, because the risks of sedating her would probably far outweigh her current condition. And then you have at C the reference to her evidence. Clinically, medically, she was very stable with us, even though there were a couple of things that were slightly lower. There wasn't anything dramatically jumping out with regards to her observations. because she wasn't clinically or medically showing any signs of distress with those, then it was outside the remit of actually physically forcing her. You, my lords, my lady, have been taken to the report of Dr. Napier, who was the general practitioner expert instructed to assist the coroner. Her report is in the first volume of the supplementary bundle, tab 6. Sorry, at tab A3. She noted that the paramedics, quote, ran into difficulties at page 106 when attempting to transport Jackie to hospital. But in respect of her evidence regarding the options available to those paramedics, she really didn't take matters very much further than to say at page 529 of the second volume of the supplementary bundle, that is at tab E2, Roman 6. I apologise, that is the core bundle, the second volume of the core bundle.
I have the page number again.
529, my lord.
Thank you.
She's there asked the direct question, so Jackie does not want to go to hospital. What are the options? Her answer, it is a terrible problem. A terrible problem, she's asked. Yes, paramedics might say, well, we will come back in a couple of hours or an hour, and they would have done the observations and able to persuade her to go, I don't know. So, insofar as she proposes a plan, it is that the paramedics return and reassess. But she recognised in her evidence, and you have this at page 541, that the suggestion that the paramedics return may not be an option and may be a silly idea. She does not appear to suggest in her evidence that a general practitioner or indeed a paramedic should have administered sedation. Finally, in respect,
Does she not consider sedation at all directly?
she does not.
She does not. Because given that the paramedic was not authorised to administer sedation, one might question what her skill and expertise is in giving evidence about the appropriateness of administering medication, but put that to one side, it may be a matter of weight. But nobody then asked Dr. Napier about that option. Is that what I understand?
My lord, certainly I was able to identify no evidence in which she gave she was expressly asked or indeed volunteered any evidence regarding sedation, but I will stand corrected if I'm wrong about that.
Thank you.
In fact, the idea of sedation came from the independent expert in emergency medicine, Dr. Good, the last part of the evidence that I wish to take forward to on the facts. His evidence begins at page 517 in the same bundle, behind tab E2, Roman 6. So far as options...
So sorry, 517 says evidence of Dr. Napier.
Oh, I apologise.
So,
It is in fact at 554.
thank you.
Oh, I'm sorry. 454. I'm having a moment of difficulty with numbers.
Yes.
He gives evidence regarding the options that in his opinion were available to the attending paramedics or indeed any attending medical practitioner at page 459, where he initially suggests that painkillers could be used if pain is the cause of anxiety or agitation. My lords, my lady, you will see over the page on page 460 that he acknowledges at F that painkilling medication would take some time to take effect, and he envisages intravenous administration of painkilling medication, and therefore, in my respectful submission, that may not necessarily be realistic within the confines of a residential placement, rather than once she arrived at hospital. But it is of significance over the page on page 461 at E, that when asked whether he agreed that there were a limited number of options available in the particular circumstances, he agreed with that. But furthermore, at G, he agreed that it was within a range of reasonable options for those attending upon Jackie to leave her where she was, which is in fact, of course, what happened. The final reference that I would like to take the court to is within Dr. Good's evidence at 463. This is part of Dr. Good's evidence that my learned friend Ms. Butler-Cole had taken the court to, in respect of his comments that the available options for the paramedics, including removal from the residential unit to hospital using restraint or force, was a grey area. He's asked, or it's put to him, there is no significant aggression.
Sorry, which letter?
I'm sorry, it begins on page 462 at H.
Oh.
Where I pick up the question at in the very last line. There is no significant aggression, in my view, being demonstrated to anybody else. And to use your phrase, this is a grey area where there is not an ideal solution, a clear solution available to any of the professionals, be it the care home staff, the paramedic staff, the GPs, that means this is clearly the way that we should proceed with Jackie Maguire. His evidence was, there is not an easy answer to this. I would suspect that if the paramedic crew at the time had been more forceful and used physical force to try and take somebody into the ambulance, they may well have been criticised. And so, in my respectful submission, whilst there were a number of hypothetical options put forward by Dr. Good as to what action could have been taken, there was no clear evidence before the coroner or the jury that Jackie could have been safely sedated to get to hospital in view of her condition and taking into account the evidence of paramedic errors. Those are the submissions that I wished to make in respect of the facts, and so I'd like to move on to the third area, which is legal principles. And my lords, my lady, I hope to be relatively brief in my review of the authorities in light of the submissions that you've already heard in the time that we have.
Miss Watson, before you move on, and I just want to quickly raise this, could you or your junior please supply the court with a reference to the occasion in this spectrum when Jackie said she wanted to see a doctor or was complaining of words to that effect? Don't let me take you off where you are now, it can come in later.
My lady, that was certainly recorded in the care home records for the 20th of February, and I will find that reference. And
thank you very much.
In essence, I would like at this stage to pick up my skeleton argument at paragraph 19. I needn't ask the court necessarily to turn that up, but it is in the court bundle behind tab A4 at page 61. In respect of the determination of whether or not Article 2 is engaged, the task for the coroner is to analyse the available evidence carefully, and of course the authorities demonstrate that a coroner may well be challenged if he or she determines that Article 2 is engaged when the evidence does not establish an arguable case of breach, and that was made clear in the case of the Crown and Plymouth County Council and the Majesty's coroner for the County Council of Devon. I don't propose to take the court to that authority, but it is, in my submission, of note that in this case the coroner was well placed to make a determination as to whether or not Article 2 was engaged in all the circumstances, because the decision that has been challenged in the court was a decision that he made or took, having heard and explored all of the evidence during the course of the inquest hearing. So far as the Article 2 general and operational duties are concerned, I do not propose to repeat the submissions that you've already heard from learned friends. However, I would like to begin with submissions of a general nature, as set out or foreshadowed in my skeleton, and take the court back, if I may, to the case of Osman. That is within the third volume of the authority bundle. Begins at page 820. The facts of that seminal case, Osman and the United Kingdom, are well known. Mr. Osman was shot dead by his son's teacher, and the applicants were that man's widow and son, and they complained that the authorities, in particular the police, failed to appreciate and act upon the warning signs that the teacher represented a threat to the family. This was a case in which it was recognised for the first time that there was an operational duty on the state to protect life by reference to the test of the test of the response to a real and immediate risk. That is set out within the judgment of the court at page 880, it's pagination within the authority bundle, paragraph 116. The duty is set out at paragraph 115, where in the judgment of the court it is stated, it is common ground that the state's obligation in this respect extends beyond its primary duty to secure the right to life by putting in place effective criminal law provisions to deter the commission of offences against the person, backed up by law enforcement machinery for the prevention, suppression and sanctioning of breaches of such provisions. It is thus accepted by those appearing before the court that Article 2 of the Convention may also imply, in certain well-defined circumstances, a positive obligation on the authorities to take preventative operational measures to protect an individual whose life is at risk from the criminal acts of another individual. The scope of this obligation is a matter of dispute between the parties. It is right to say that at paragraph 116, it was made clear that not every claimed risk to life can entail for the authorities a convention requirement to take operational measures to prevent that risk from materialising. And so there we find the gateway test of real and immediate risk, which has been considered subsequently to set a high threshold and which rigorously excludes the application of hindsight. confirmation of the high threshold set can be found in the case of Re-Officer L. That is within the first volume of the Authorities Bundle at page 285. With the relevant passage at paragraph 20 appearing on page 293. The case of Re-Officer L concerned the death of a gentleman in an affray in Northern Ireland, following which a public inquiry was set up. Police officers whom the inquiry proposed to call applied for anonymity on the ground of a risk to life if identified, and it was contended on behalf of those police officers that there would be a breach of Article 2 if they were required or compelled to give evidence without anonymity. Lord Carswell, at paragraph 20 of the House of Lords judgment, having reviewed the jurisprudence, said that two matters have become clear in the subsequent development of the case law. First, this positive obligation arises only when the risk is real and immediate. The wording of this test has been the subject of some critical discussion, but its meaning has been aptly summarised in Northern Ireland by Mr Justice Weatherup in Re W's application at paragraph 17, where he said that a real risk is one that is objectively verified and an immediate risk is one that is present and continuing. It is, in my opinion, clear that the criterion is and should be one that is not readily satisfied. In other words, the threshold is high. The obligation of enhanced investigation under Article 2 has been extended incrementally by the courts to other classes of case, i.e. not simply those involving a threat to life in the context of policing, but in cases involving those detained in prison or where state operations have given rise to a danger or a risk to life. In my submission, the Strasbourg Court has consistently held that the Article 2 investigative obligation does not apply to what I will term ordinary clinical care. I intend to take the court briefly again to Fernandez, but before I do so, in order to address the appellant's first ground, it's necessary in my submission to look in a little more detail at the domestic cases where it has been considered that the Article 2 investigative obligation can and cannot apply. Beginning, if I may, with the case of Savage, which is behind tab 15 of the first volume of the Authorities Bundle. The report begins at page 408. This was a decision which established that the Article 2 protective operational duty was owed to detained patients under the Mental Health Act to protect those patients from a suicide risk. The general ambit of Article 2 was addressed in paragraphs 18 and 19. At page 421. Article 2 was set out by Lord Roger at paragraph 18, and at paragraph 19 he went on to say that fundamentally Article 2 requires a state to have in place a structure of laws which will help to protect life. And he refers back to paragraph 115 of Osman. He goes on at H to say that as the parties in Osman's case recognise, the state's duty goes further, and Article 2 may also imply, in certain well-defined circumstances, a positive obligation on the authorities to take preventative operational measures to protect an individual whose life is at risk from the criminal acts of another individual. The phrase certain well-defined circumstances has perhaps become rather unhelpful given the subsequent search for a clear definition or clear test for when Article 2 should apply. But in my submission, the authorities demonstrate that the duty varies according to the context. The case of Osman was a case, of course, regarding criminal law enforcement. It was a case about police action or inaction. But the way that the court has reasoned in Savage, in my submission, was by analogy, extending the duty over time to protect prisoners, army conscripts, and in the case of Savage, a patient detained under the Mental Health Act. The nature of the duties was explained by Lord Roger in the Savage case at paragraph 39. That is at page 428. Lord Roger said the cases on prisoners and conscripts suggest that the court sees Article 2 as imposing an obligation on the state to take appropriate practical measures to prevent them committing suicide because they are under the control of the state and placed in situations where, as experience shows, there is a heightened risk of suicide. Since in other respects the predicaments of the prisoners and conscripts are different, the other factors which contribute to the risk and so give rise to the obligation are not the same. For instance, the position of vulnerability of the prisoners is stressed. The human reaction to being called up to do military service is mentioned in the case of the conscripts. The thread in my submission begins to come through here and is pulled further in the case of Rabone, that there are characteristics of control of the state over the individual, a causal connection between the control of the state and the level of risk and position of responsibility that an individual has been put in by the state. Teasing out those characteristics, the House of Lords in Savage held that the same principles should apply and do apply to detained mental patients. They were considered to be in a comparable condition to prisoners and conscripts. And the decision of the court is summarised in paragraph 49, page 431. Lord Roger states the fact that Mrs. Savage was not only a patient, but a detained patient is also relevant to the authority's obligations under Article 2. Any auction in the comparative vulnerability of prisoners, voluntary patients and detained patients would be as unedifying as it is unnecessary. Plainly, patients who have been detained because their health or safety demands that they should receive treatment in the hospital are vulnerable. They are vulnerable not only by reason of their illness, which may affect their ability to look after themselves, but also because they are under the control of the hospital authorities. Like anyone else in detention, they are vulnerable to exploitation, abuse, bullying, and all the other potential dangers of a closed institution. In my respectful submission, this passage provides great assistance in identifying the character of cases in which the Article 2 investigative obligation should apply. It is not only vulnerability due to underlying illness, but vulnerability caused or contributed by the control of the state.
I think to that extent you and Ms. Butler agree, because that seemed to be where she ended up yesterday.
Well, I will come on to submissions regarding Jackie's vulnerability, but it is my respectful submission that it was by virtue of her underlying condition, rather than the control of the state, that she was vulnerable. In addition, it's my submission that paragraph 49 of Savage provides assistance in identifying the characteristic of cases in which Article 2 applies by reference to the nature of the detention, that is to say, detention in a closed institution. And so, where deaths occur, in effect, behind closed doors, where an individual is vulnerable by reason of state control, there is a presumption or an expectation that the state will be called to account if an individual in those circumstances dies a violent or unnatural death, and that is, of course, a further feature of the cases in which an Article 2 obligation has been held to apply. The judgment in Savage doesn't entail any detailed analysis of the degree of vulnerability or the degree of risk that is required to trigger the Article 2 obligation, but in my submission, the cases of detention, as opposed to this case where there is a deprivation of liberty, the pointers are an acute vulnerability and an acute risk tied to the closed nature of the detention, as opposed to a chronic vulnerability due to a chronic condition, or a chronic risk as a result of a chronic condition, in relation to somebody who is not in what could properly be described as a closed institution. The next authority that I'd like to take court to again is Ragone, and I can deal with this authority, I hope, quite shortly. Extensive reference having already been made to the judgment of Lord Dyson, and in particular passages, paragraphs 22 to 25.
That's in volume.
I apologise, that's volume 2 of the
Yes.
authority bundle. The report begins at page 723.
Yeah.
The obligations under Article 2 are set out in outline in paragraph 12 on page 734. And the indicia, now very well known indicia, that Lord Dyson has developed following the decision in Savage are set out in paragraphs 21 to 24. They are in effect threefold. They concern the assumption of responsibility by virtue of control exercised over an individual by the state, vulnerability, and nature of risk. And it is within paragraph 22 that the paradigm example of assumption of responsibility is given as the detention by an individual by the state, whether in prison, psychiatric hospital or immigration detention centre or otherwise. And so far as vulnerability is concerned, reference is made to sufficient vulnerability, and therefore not vulnerability per se. And in respect of the third indicia criteria, the nature of the risk entails identifying whether or not it is an ordinary or an exceptional risk. It is apparent from submissions that I've made this morning that I say it is a key feature of Jackie's case that she was living in a residential home in the community, not a closed, secure environment that would be analogous to a prison or a secure psychiatric hospital. I also submit that the nature and extent of Jackie's accepted vulnerability and risk differentiates this case from the Rabone line of authorities, because it is not the same type of acute vulnerability as a prisoner or a detained mental health patient. Jackie had a chronic lifelong vulnerability due to an enduring health condition. And in my submission, the risks she faced were not exceptional risks, but ordinary risks that arise as a result of her enduring health condition. And those are, in my respectful submission, the salient features of Jackie's case, which take her outside the Rabone line of authorities, which mean that, in my submission, one cannot reason by analogy to apply the Rabone reasoning. And in my submission, this is a case that falls within the Parkinson line of authorities, or ordinary clinical care, or ordinary health care.
Yes.
Paragraph 25 of Rabone is a paragraph to which the court has already been taken, but it is of significance because, of course, Lord Dyson makes clear that whilst he has endeavoured to pull out certain characteristics or indicia that may point to the engagement of Article 2 in any particular case, he was not intending to set down what he called a sure guide. However, it is my submission that the European and domestic authorities are reasonably clear that there are certain circumstances which will automatically trigger the investigative obligation under Article 2, and those cases are cases of a violent or unnatural death in detention, or a violent or unnatural death at the hands of the state, either because the state has directly caused death. An example of that would be in cases of a police shooting, or in cases where the state has created the danger that has caused death. And within that category, one can see cases such as the case of Watts, to which my learned friend Dr. Cole made reference. The state has created the danger by moving, or would create the danger, by moving vulnerable elderly residents from one care home to another. Or in the Ulcer and Turkey case, where the state authorities maintained a dangerous refuse tip close to a residential area. It's my further submission that the jurisprudence makes clear that there are certain classes of case that will not trigger the Article 2 obligation. Those are cases of ordinary clinical care.
I think we have covered some of this ground, haven't we, Ms Watson?
And yes, I'm simply going to add that analysis in my submission is consistent with the judgment of the court in Tyrrell. I don't propose to take the court to that case because you've already been taken to the relevant passages, but you'll find that within the second volume of the authorities bundle at page 773, the key passages being paragraphs 33 and 38, to which my learned friend Farbey referred. If I may deal as swiftly as is appropriate with the second class of case, where the Article 2 obligation is not automatically triggered, the healthcare cases, and the decision of the Grand Chamber in Fernandez. Extensive reference has been made to this judgment. It is within volume 3 of the authorities, begins at page 141. The relevant passages beginning at page 106, beginning at paragraph 162 on page 1079. The court has been clear in this regard. As set out at paragraph 166 on page 1080, in the particular context of healthcare, the court has interpreted the substantive positive obligation on the state as requiring the latter to make regulations compelling hospitals, whether private or public, to adopt appropriate measures for the protection of patients' lives. However, it has not excluded the possibility that acts and omissions of the authorities in the context of public health policies may in certain circumstances engage the contracting party's responsibility under the substantive limb of Article 2. These passages, in essence, repeat what was set out by the European Court in Powell in the United Kingdom. The point is simply made by me in these submissions that where the state has made adequate provision, that is sufficient. There will not normally be an operational duty. Where there is a regulatory framework which operates effectively, Article 2 will not be engaged where there are allegations of failures in respect of the provision of healthcare. So far as deficiencies are highlighted in the regulatory framework, it is important to keep in mind in my submission what was said by the court at paragraph 188 in Fernandez. That is on page 1084. The question of whether there has been a failure by the state in its regulatory duties.
Well, I think we've already been shown this. So
Yes.
I've highlighted it, so I think we needn't have read again passages that we were taken to yesterday by Ms. Butler-Cole.
Of course, for the purposes of my submission, I simply stress the reference to the need for a concrete assessment of the alleged deficiencies rather than an abstract one, which must be shown to have operated to the patient's detriment. It is not appropriate, nor will it trigger an investigative obligation under Article 2, if an individual simply makes hypothetical statements about what could or could not be done, or what deficiencies there may be in a system. There must be precision, and as was set out in both Fernandez and repeated in Parkinson, there must be a genuine and objectively verifiable dysfunction in an actual rather than abstract system.
Yes.
I will touch on only two further authorities. That is Parkinson, which I can deal with incredibly briefly, given the extensive citation that you've already had, and the admissibility decision in Dumpy in Latvia, which I had discovered, I'm afraid, rather late in the day, but which, in my respect for submission, it is closely analogous to the facts of this case and therefore relevant. The Parkinson decision is found in volume 2 of the authorities bundle, beginning at page 790. The summary of the relevant principles in Article 2, which the court has already been taken to, begin at page 803. Paragraph 86 makes clear that the enhanced duty requires an arguable breach. And paragraph 87, again, like Fernandez, repeats what was set out in Powell, that the requirement under Article 2 in ordinary cases of medical care is that there be an adequate and effectively operating system of regulation. Of relevance to my submission is paragraph 88, where, as in Fernandez, it was recognised by the court in Parkinson that there may be exceptional cases which go beyond mere error or medical negligence, in which medical staff, in breach of professional obligations, fail to provide emergency medical treatment despite being fully aware that a person's life would be put at risk if that treatment is not given. And at paragraph 89, where the court states that at risk of oversimplification, the crucial distinction is between a case where there is reason to believe that there may have been a breach which is a systemic failure, in contrast to an ordinary case of medical negligence. When I come to deal with the grounds of appeal, it is my submission that this is a case where the alleged failures are plainly ones that are allegations of failures in ordinary clinical care, should properly be characterised as allegations in effect of medical negligence.
Yes.
And I rely upon the case of Dumpy in Latvia, which was handed
Back
up,
of
and
volume
I
3.
believe this decision, albeit an admissibility decision, is in my submission significant because the facts are closely comparable to those in Jackie's case. This was a case in which the individual who died had been placed in a social care home, albeit the system in Latvia may not have described it in the same terms as Jackie's here as a deprivation of liberty. It is, in my submission, on the facts analogous. And the concerns raised by the deceased mother were of failures in the provision of appropriate clinical care. At paragraph 48, the court sets out the nature of the complaint by the applicant. She complains that her son, having been placed
Well, we've
in a
had this read to us already.
yes, that a social care institution has not been provided with adequate medical assistance. That is, in my submission, precisely what it is that Mrs Maguire, the appellant in this case, is complaining about in respect of Jackie. And it is significant, I don't intend to take the court in detail to paragraphs 56 to 57, because they have too already been read to you. But it is significant that the court concluded that the facts of this case were such that it should properly be viewed as a medical case, to which the Fernandez line of authority and not the Campagnou and Jasinskis line of authority applied.
I mean, whilst that it's clear that that's what the court was doing, we shouldn't lose sight of the fact that the reason it was declared inadmissible was not on that basis, but in paragraph 77 on non-exhaustion of remedies.
Indeed.
And that's why they spent so much time looking at the alternative processes that were available.
Indeed, my lord. But coming on then to the final area of my submissions, the grounds of appeal, it is my submission that the characterisation of the Dumpy case as a medical case is significant, because that is essentially the nub of the first ground of appeal. Was the coroner and the divisional court correct to conclude that this was appropriately categorised as a case of ordinary medical care, to which the Parkinson line of authority applies? And in my submission, the coroner was correct to do so, and the divisional court was quite correct, having reviewed the applicable both domestic and European authorities, to affirm that decision. And the support in my submission comes, as I've already indicated, from consideration of the character of the regime in which Jackie was cared for. I summarise, it is not akin to detention. And support comes, secondly, from consideration of the character of the concerns that have been raised by Miss Maguire's family. The divisional court were quite right in its judgment at paragraph 45 to note that the failings identified related to individual actions arising from the provision of medical care and treatment to Jackie. Thirdly, the coroner and the court were quite right to consider the cause of death. This this was not a violent or unnatural death, but indisputably a death due to natural causes. And fourthly, it is important to consider whether Jackie's case is truly analogous to any of the authorities, both in domestic and European jurisprudence, in which Article 2 has been found to be engaged. And in my submission, it is not. This is plainly not a denial of treatment case, like the case of Jasinskis, to which my learned friend Ms Butler-Cole referred. It is a case which, at its highest, alleges delays in ensuring that Jackie was admitted to hospital. Not wishing to repeat the submissions that I've already made, insofar as the Rabone indicia are concerned, which are relevant but not determinative, there is no compulsion actually used in the detention of Jackie within the residential placement. And so that is relevant to the degree of the assumption of responsibility. And it is a placement which is akin to her own home, in my respectful submission, so far as access to medical services is concerned. The second indicia of vulnerability, as I've already highlighted in my submissions, it is a vulnerability which arises as a result of a chronic and lifelong condition, not an acute vulnerability of the type identified both in Rabone and in the jurisprudence reviewed in Rabone and subsequent decisions. In respect of the third indicia, there is no exceptional risk identified here. It is an ordinary risk of death arising from a physical, naturally occurring condition. As Dr. Miller indicated in his evidence, the development of and perforation of a gastric ulcer could happen to anyone. And thus, in that summary fashion, it is my submission that applying the Rabone indicia provides support for the conclusion of the Divisional Court that Article 2 was not engaged in this case. One final point in respect of ground 1 is to note that in my submission the deprivation of liberty safeguards themselves and the fact that Jackie lacked capacity were not considered to be particularly relevant features so far as the provision of medical care was concerned, or indeed the delays in the provision of medical care were concerned, as both experts who gave evidence to the coroner, Dr. Good and Dr. Napier, felt that there were actions that could have been taken regardless of those features, regardless of the deprivation of liberty safeguards, regardless of Jackie's lack of capacity. In respect of grounds 2 and 3, I can be relatively brief. Ground 2 relates to systemic failure.
Yes.
If, in fact, Parkinson does apply and the court were correct so to find, was there a systemic failure? In my submission, the concrete analysis that is required by the Devon and Cornwall case is distinctly lacking in this case. I hadn't taken the court to the Devon and Cornwall case in any detail, but you will find it in volume 2 of the authorities, behind tab 23 at page 766.
Would you like just to give us the reference rather than read it?
Certainly. It's a very short judgment. It begins at page 766 and the facts are set out in the head note, a case involving an individual who takes his own life when driving his car, having been signalled by a police officer, dying as a result of driving into the path of an oncoming vehicle. the relevant parts, so far as the court is concerned, are also on page 766, where it was made clear that it was important in cases in which it is alleged that there was a systemic failure to identify what the system was that should have been in place, what the system should have been. And the court sets out in paragraph 7 on page 768 and paragraph 20 on page 771 that any criticism made of a system must be based on evidence. And it is my submission that the allegations here of a failure to have a care plan in place which provided for the action to be taken in the event that Jackie refused emergency medical treatment is based on no evidence at all. No evidence was led at the inquest as to whether there should in fact have been a plan that was as specific as that, nor indeed was any evidence led as to what such a plan should include. And I have referred the court to the expert evidence, which amounts to this. The options available were limited. It was a very difficult situation faced by those attempting to provide Jackie with medical care, and they could provide, even with the benefit of hindsight, no clear indication of what the plan ought to have been. Furthermore, there was no evidence before the court. There is no evidence before the court, and was no evidence before the coroner and the jury that a specific care plan which endeavoured to identify what action should be taken in the event that Jackie refused to accept emergency medical care. There's no evidence that that would have led, in fact, to Jackie receiving hospital care any sooner than she did. The evidence led at the inquest was that Jackie was amenable to encouragement, and where she would initially refuse to engage, she could be encouraged to do so. Insofar as that was an option, that option was followed. And there was evidence at the inquest that the paramedics tried to encourage or cajole Jackie into accepting care and treatment from them, that carers, support workers also tried to do the same. The court has before it a general care plan that was produced for Jackie. Rather than being prescriptive, it identified the areas in which she required support. That, in my submission, is entirely appropriate in the context of the provision of social care by those who are not medically qualified. It would, in my submission, be difficult for those providing non-medical support in a care home to anticipate all eventualities and prescribe a course of events which may include the administration of medication to ensure that Jackie was able to be transported to hospital in an emergency situation when that was obviously indicated.
Yes.
This was not a case in which there was a denial of access to emergency medical treatment, but where there was knowledge that Jackie's life was at risk, as per Fernandez at paragraph 191.
I think you're slightly repeating yourself now.
My Lord, yes, just in summary, there is no objectively and genuinely identifiable systemic dysfunction which caused Jackie's death here. There simply isn't any evidence to support that submission, or indeed that ground of appeal. I would ask the court to keep in mind what is set out in my skeleton argument back to core bundle 1, tab A4 at paragraph 48. Whilst the learned friend Dr. Cole has drawn the court's attention to a negative report on the quality of care and indeed the systems in place at the residential unit, I to draw the court's attention to a subsequent Care Quality Commission report, which points in the other direction. And I set out at paragraph 48 of
Well,
this
we
version
certainly
onwards.
have it, and I think we are an appellate court dealing with alleged errors of law, and we're not going to be making factual findings. So, but we have those points.
Indeed, my lord.
I'm concerned. I'm just concerned to hurry you because you suggested you would be an hour, and you've been an hour and 3/4, and it's clear we're going to have to hear the reply after short adjournment, unless it's very quick. And I don't want Miss Butler Cole to feel that she is in any way constrained in time. So forgive me if I try to hurry you a little.
I quite understand. I've fallen into the trap that myself and many barristers do, which is giving a grossly inadequate estimate of my time.
Well, we've all been guilty of it in our time, so don't worry too much.
I can move on and be very brief in respect of ground 3.
Yes.
Whilst the Leader and Sippold reports may have been known to the coroner, they were not in evidence at the inquest, nor had those reports been disclosed to the other interested persons in that inquest. Whilst the contents of those reports are arguably relevant to the coroner's jurisdiction in respect of preventing future deaths, those reports, in my respectful submission, have no relevance to the coroner's decision on Article 2. In my submission, the Divisional Court were quite right to note that general and academic literature can have no bearing on whether the state breached the substantive obligation in Jackie's case. And I respectfully agree with and adopt the submissions made on behalf of the coroner in his skeleton argument at paragraph 40 on page 55 of the core bundle. That is, that it would be very difficult if the coroner were to take into account his personal knowledge of reports when deciding whether to leave an extended Article 2 conclusion to the jury, when the jury themselves would not be possessed of the knowledge that the coroner had and would therefore be unable to take that into account.
Yes.
And so whilst there may be a fine line in cases such as this, where the degree of vulnerability and assumption of responsibility for the welfare of an individual such as Jackie is less than detention cases but still present, it is my submission that the coroner was correct to conclude on the application of the principles from both domestic and Strasbourg case law that Article 2 was not engaged in the circumstances of this case. I can briefly indicate that so far as relief is concerned, in light of the full, fair and fearless inquiry which all parties agree was carried out by this coroner, it would, in my submission, be disproportionate if the appeal were to be allowed to order a fresh inquest. And not making any detailed submissions, I would refer the court to the case of Tainton, which I understand is going to be handed up in the course of further submissions on relief on behalf of the coroner. I would endorse the approach that was taken by the court in that case.
Thank you.
Unless I can assist in further.
No, thank you very much indeed.
My Lord, it's 5 to 1, and I have taken the precaution of producing a written reply. And so, if my Lords and my Lady are willing to sacrifice 5 or 10 minutes of the lunch adjournment, I will be able to deal with that just by handing it up and making 1 or 2 observations. Mr. Beer then has about 5 minutes of submissions and some authorities on the question of relief. So between us, we think we'll be finished by 1:10.
Well, if your estimate of finish by 1:10 is a real estimate as opposed to what might be called a lawyer's estimate, then unless it substantially inconveniences anyone else in court, I suggest we carry on. Just before you do so, Mr. Maguire, you've been sitting patiently. It's right, is it, that you've got no oral submissions that you want to make? Good.
But if I may hand up the written reply, thank you. The question my lady raised about the care home not calling a GP when Jack like he asked for one. We found the underlying care record. It's not in the current bundles, and I only have one paper copy. If the court would like one paper copy now, I can hand it up, or 3 proper copies later on.
I suggest 3 proper copies later on.
Thank you. In relation to the reply, I've had to amend it by hand this morning, so I apologise for that, any scrappiness in the note. The 3 points that I just want to highlight are the second page. I have perhaps rashly tried to identify possible hypothetical scenarios to test the case of the coroner and United Response about where the limits of Article 2 properly are. And in the footnote, the court may be interested to note that the government has actually provided public guidance on how to encourage people with learning disabilities to access dental treatment because of the known risks to that population of not doing so. And that is one of the areas that we say in this case was sorely lacking guidance of that sort in relation to admitting people with learning disabilities to hospital in an emergency, which is again a known difficulty. So the court may be interested to note that. The other matters are firstly the question about what would have happened, that my Lord asked yesterday, what would have happened if the coroner had said Article 2 was engaged. And I've set out paragraph 8 some questions of the sort that may have been then suggested to the coroner to consider leading to the jury. What I've also included at paragraph 11 reflects the discussions yesterday. My learned friend Mr. Beer was saying that in some inquests 40-page questionnaires are left and so on and so forth. If the court is minded to say anything about practice in this area, it struck me that it might be more helpful to have some actual records of inquest to understand what is actually done in these sorts of cases. There's no publicly available database, unfortunately, but the charity inquest has access to them. And overnight, they very helpfully sent us 4 records of inquest, deaths of people with learning disabilities from either natural causes or sudden death. Some juries, some not. They show a range of conclusions from a couple of sentences to a couple of pages. If the court would be assisted, I can hand them up. If the court's not minded to think about this in further detail, I don't need to.
Well, speaking for myself only, I would find it helpful to look at them, and again I wonder whether it might be more convenient for a sort of composite bundle of extra materials to be provided after we finish the oral argument.
Yes, and that takes me to the last point, which is relief, which I've dealt with in paragraph 12 of the reply. Mrs. Maguire's position is that a full inquest should be carried out. However, to assist the court, I've set out some other authorities and details which will show the court what its other options might be.
Well, those were what I had in mind, to be frank.
And I think Mr. Beer wishes to make some further submissions on that issue.
On tainter, yes. And the Jarvis you refer to in paragraph 16 is
the textbook.
Yes, but there's a brand new edition, isn't there?
Yes, I hope that what's been copied already is the new edition. I'll check that.
It is good. That's reassuring. Well, thank you very much indeed. That's an extremely helpful way of presenting your reply. Yes, Mr. Beer, you're going to give us Tainton.
Could I try the court for 8 minutes that I've now got, it's expanded, on relief, picking up on the second question that Lord Chief Justice asked yesterday. In fact, it wasn't me that was going to hand Tainton in. I think it was in fact Miss Butler Cole. I was going to hand in 3 other cases, which I'll do now. Can they go behind? We'll add Tainton as well in a moment. Could I ask that these go behind your second volume of authorities? And I tap them.
Thank you very much.
There is a second one because they're domestic. I tap them 25A, B and C.
Yes.
You will have just seen that Miss Butler Cole said in paragraph 12 of her written reply that Mrs. Maguire considers a fresh inquest should be carried out, but then perhaps realistically and temptingly, in paragraphs 13 and following, she sets out the other options available. Just in relation to the new inquest issue, I'm going to make submissions in a slightly odd order here first. I'm going to set out the factors that the court might wish to take into account, and then look at the authorities very briefly. The court may wish to take into account, I'm making again no positive submission here, the following 8 factors. First, the fact that it's accepted that the coroner's investigation was full, frank and fearless. Second, there is no question but that the short form verdict that was recorded was the appropriate short form verdict. So this isn't one of those cases where the short form verdict is wrong. Third, the fact that many of the facts which will be recorded in a narrative conclusion are already in fact recorded on the face of the record of the inquest. Fourth, the coroner made a full prevention of further future deaths report, which is not criticised in respect of either scope or contents.
Do you have the reference for that handy, Mr. Beer?
Yes, Core, Volume 2, page 578.
Thank you.
Fifthly, the court will wish to take into account the wishes of the family. Sixth, the delay which has elapsed since the events under consideration. 3 years or so. Seventh, the fact that a large number of witnesses, at least 29 on the last occasion, would have to give evidence again about what is obviously a traumatic and distressing event. And then lastly, the court may wish to take into account the extent to which a declaratory judgment of the court would suffice. Those are the factors that I'm trying to pull from the authorities as being a range of things to take into account. Dealing with the authorities then, 25A, tab 25A please, a decision of Lord Justice Rose in a case ex parte Tonkin. I'm afraid this is the only format in which it's available, and therefore back in the day paragraph numbers were not in vogue. If we can go to the 5th page of the report please, which starts in the second paragraph with the words Mr. Burnett accepts.
It's not one I remember, but it's a very long time ago.
Yes. This was a case where the coroner, it was accepted, had failed to leave an additional verdict of non-dependent drug abuse, to which could be added the rider lack of care or neglect. So the primary verdict was the correct one, but the coroner had failed to let the jury do something that he ought to have let them do. So that's why I put it before the court, because it's, if the appeal is allowed on this cold basis, an analogous situation. In the second paragraph on that page, you'll see the court records there are 4 possibilities. In the 4th paragraph, Mr. Rimmer submitted that though the verdict is sustainable, it doesn't go quite as far as it should. The court is then referred to a number of even older authorities. And then by the second hole punch, this is clearly a case, not a case in which the extent of the jury's verdict is unfair to the deceased young man. That's an important point, that it's not the wrong way round, the verdict. Mr. Rimmer submits that if there was a reference to the verdict to neglect, that might possibly reduce substitutes the sting of his own death and having been caused by that which he unwittingly did. So this was an appropriate, albeit incomplete, verdict. And if the court allows the appeal on the basis contended for, that would be the position here. And then the court will see the discussion that follows as to, in those circumstances, whether there should be a new inquest. And what motivated the court was that the jury could, if the additional facility to record a verdict of non-dependent abuse of drugs contributed to by lack of care or neglect, could or could not have returned that verdict. There are substantial arguments in relation to both those matters. And that may be the view that the court takes here, that if the appellant is right, then what would have had to be left to the jury was itself the question, as I submitted yesterday, of whether there was a really immediate risk to life, of which the authorities ought to have known. The second case, much shorter and well known to the court, of ex parte Douglas Williams, I put before the court just because it sets out the test that falls to be applied. At page 347, between C and F, please. Page 347 between C and F. This case was a statutory review under section 13 of the Coroner's Act, but Lord Wolfe had said that that didn't make any difference. And right between E and F, he said when it comes to exercising the discretion, that's as to the relief to be granted and whether a new inquest should be ordered, I cannot suggest a better test for the court to apply than it should be, quote, necessary or desirable to do so in the interest of justice. So that's the underlying test.
Yes.
As to the issue of, so that's new inquest. As to the issue of the court substituting its own conclusion into the record of inquest, the third authority that I've put before the court, I hope helps on that. It was a course that Mr. Justice Mitting had taken in the well-known case of long-filled care homes. And in this case, Mr. Justice Wilson in Nolan rather drew back from the suggestion that it was appropriate in many cases. I would respectfully refer the court, in the interest of time, to paragraphs 6, 7, 18 to 20, and 22 to 26. When, in due course, the court reads those, the court will see that His Lordship suggested that the court must exercise great caution in substituting its own views.
Yes.
In particular, where there are disputed issues of fact and issues of qualitative judgment about what evidence meant.
What had changed between this case, Molam, and the first you showed us, Tomke, is that a power now exists to do that. It didn't exist in 1995.
Yes.
But Mr. Justice Wilson is really making a constitutional point that
yes.
Making these judgments, finding facts and evaluating is assigned to others, not to the court.
Yes, and since then the position's changed still further. You will have seen that Mr. Justice Wilson was exercising a jurisdiction provided to him under the CPR. Now the position is governed by section 31, 5A of the Senior Courts Act 1981. The court can substitute its own decision if the decision in question was made by a court or tribunal, correct. If the decision is quashed on the ground that there's been an error of law, we're assuming that there are for these purposes. And then C, without the error decision which the court or tribunal could have reached.
Yes.
That's the jurisdiction now, which is slightly different even to what Mr. Justice Wilson was considering. That brings us lastly then, a couple of minutes of the time, to the authorities that I think Ms. Butler-Cole was going to hand out, which were that section from Jervis and the decision in Tainton.
So should we pop those at the back of volume 2 as well?
Yes.
Many thanks.
Tainton, just before to mention, paragraph 79 to 83, right at the end. The court may feel that that's an appropriate approach, i.e. a declaratory judgment, because one then doesn't come up against the buffers of section 31 of the 1981 Act about substituting its own view into the record of inquest.
Yes. And the passages in Jarvis reflect the authorities, do they? Is that what we've got them for? And we've got Longfield as well.
Yes. Yes, Longfield, I think it has been included for completeness.
Yes.
It's been long overtaken by events. Jervis is helpful because at 1969 it sets out that test that I just described in section 31 of the 1981 Act. As I said, I haven't made a positive case on relief.
No, we understand that. It's very helpful. Thank you very much indeed. Well, can I thank all counsel and all those who have been supporting them for the extremely helpful submissions we've had in what is not an altogether straightforward case. We will take time to consider our judgment or judgments. We will circulate our judgment or judgments in advance of handing down in the usual way to enable the parties to make suggestions for typographical errors and obvious glitches or solecisms. We emphasise that it's not an opportunity to re-argue any of the points. We will then arrange to hand down judgment. We would invite the parties to try to agree on an appropriate order in the light of the content of the judgments. In the event that it's not possible to agree an order, we will deal with any points of disagreement on short written submissions, and there will be no need for anyone to attend the handing down of the judgment or judgments unless they have a particular desire to do so. So thank you very much indeed.